survivor-centered advocacy by enhancing the work of lawyers and advocates, by organizing communities, and by offering leadership on critical issues facing survivors, attorneys, and advocates. And for the most part, CSAJ has two main focus areas. The first area is survivor-centered advocacy skills. So we have spent quite a bit of time working with lawyers, advocates, and programs on thinking about how to translate survivor-centered principles into practice, how to ensure that our work is really being driven by the self-defined priorities of survivors themselves, regardless of subject area. And then the second area of focus is economic justice advocacy. For many years, it's been very clear to us, as with other advocates across the country, that economic advocacy is a critical need for many survivors. And so a large focus of our work has really honed in upon that. And the project that is bringing you today's webinar is a piece of that economic justice work. So let me talk a little bit about that. So the Consumer Rights for Domestic Violence Survivors Initiative is a national project of the Center for Survivor Agency and Justice. CRDVSI seeks to enhance consumer rights for survivors by, on the one hand, building the capacity of, and on the other hand, forging partnerships between domestic violence and consumer lawyers and advocates. And it's really this partnerships building piece that is a new focus of our work, based in large part upon what we've learned over the past several years, that there's a real need for bridging that gap between domestic violence advocates and consumer advocates. Our current project is funded by the Office on Violence Against Women at the Department of Justice to provide technical assistance to LAV, rural and rural grantees, as well as other non-governmental organizations that provide services to domestic violence survivors. We have several key partners on this grant project, and the first is the National Consumer Law Center, also the National Law Center on Homelessness and Poverty, the Feerick Center for Social Justice, which is based out of the Fordham Law School, as well as a cadre of expert advisors who hold unique expertise in the intersection of domestic violence advocacy and consumer rights. I want to talk real quickly about how we do our work. I've kind of outlined it here, but the first is through national conferences. Back in October, we held a national one-day intensive institute as part of the National Consumer Law Center's annual conference, and it focused specifically on consumer rights advocacy for domestic violence survivors. We'll be having another one of those this coming fall as well. We host a number of webinars like the one that we're hosting today, and if you're interested in accessing past webinars, you can go to our website for that. They are all recorded and up there. We also provide individualized technical assistance, so in other words, problem-solving, case strategizing help. When people have concrete issues that they're grappling with, we are happy to draw upon all the resources and people that we know across the country to help do some problem solving. We have a whole bunch of online resources on our website. And we also, lastly, this last piece is the Building Partnerships Pilot Project. We're in the midst of doing some really interesting, I think, innovative work that, again, is pulling together the domestic violence and consumer rights expertise in different communities across the country, and we'll be working intensively with a handful of pilot projects. So if you want to learn more about any of the things that I've just mentioned or to access our resources, you can feel free to check out our website, which is listed here, or send us an email. So without any further discussion of our project, I would like to introduce our webinar right now, which is going to be focusing, as Sarah said, on foreclosure advocacy for survivors. I'll be serving as the moderator throughout, so we really do encourage you to participate or ask whatever questions you might have along the way. Karen, our faculty, will be taking some breaks and at various stopping points throughout. So I will keep my eye on the chatter, and just rest assured that I'll make sure that we address it at different moments throughout. So today we are very lucky to be joined by Karen Tjapkes. She's an attorney and director of the Home Ownership Preservation Project at Legal Aid of Western Michigan in Grand Rapids. Her practice is concentrated on consumer law, housing law, and mortgage litigation. She's been with her organization for over 10 years, and she worked previously in the Big Rapids and Kalamazoo offices. She's also taught consumer law as an adjunct professor and lecturer at Cooley Law School in Grand Rapids. So all of that said, I'm so thrilled to have you with us today, Karen, and I'd like to hand the program over to you.
All right. Can you hear me?
We can hear you.
Okay. Hold on. Okay. Technology is difficult sometimes. Thank you very, very much, everyone, for inviting me to speak and then actually attending to listen to me speak. I hope this is going to be useful information for you. I just want to go ahead into my polls here because I want to get a sense of the audience, especially since I can't see you, to get an idea of who is with me and to make sure that I'm sort of gauging this at an appropriate level for everyone to get the most out of it. So the first question I have here is I want to get a sense of if you consider yourself more of a domestic violence attorney or advocate, more of a consumer law or a foreclosure attorney or advocate, or do you feel like you've got a foot in both of those worlds? So if we can go ahead and you can click your answer to that.
Right, so the question is at the bottom of the screen to the right.
Pretty much everybody's answer. I'm going to close the poll. It'll close in about 15 seconds.
All right, do we have an answer?
It should pop up just 1 second.
Okay, so it looks like out of 67, it looks like about 30% of folks are identifying as domestic violence. Lawyers or advocates, 24% as consumer foreclosure folks, and then about 19% of people are saying that they've got some of both expertise.
All right, good to know. And then the next question I just wanted to get a sense of is what's your background or your level of knowledge about foreclosure specifically, if you want to go ahead and answer that.
Just give folks a couple more seconds to, that's just about everybody.
There we go.
Okay, great. Looks like a little bit over half are beginner.
Okay.
16% intermediate, and a small percentage are experts.
Okay. All right. Yeah, I will say the experts, feel free to check your email because this might be pretty basic for you, but I think that was about the experience level I was expecting. So hopefully those of you who are a beginner you'll feel like you'll get some good foundation here. So we'll go ahead and launch into the presentation. Thank you very much for taking the polls. I just want to begin by saying that every state handles foreclosures differently. Foreclosure is definitely a function of state law. And so while my comments are going to be rather general comments across states, to the extent that you're working with these foreclosure issues and helping survivors, you're going to want to get some hands-on specifics about your own state. The National Consumer Law Center on their website does have a summary of each state's procedures, but I would encourage you, again, to find someone in your own state who can go through the specifics with you. Basically, there are two basic types of foreclosure, a judicial foreclosure and non-judicial foreclosure. And the difference is kind of what the name implies. The judicial foreclosures go through a court process with some sort of court oversight, and then the non-judicials do not. They're either they're sales that are conducted sometimes by a trustee in some states, especially in the western states, or it's just done by advertisement without a trustee or quite frankly, really oversight at all. If you've heard that you're a deed of trust state, those are usually the non-judicial states, and a deed of trust and mortgage are going to be pretty much synonymous or the same for our conversation today, just so that we're all kind of on the same place with terms. Okay, so I want to get a little bit of feedback from you here. So say that you are working with a survivor who is going through a divorce proceeding or some sort of domestic violence proceeding. She contacts you and indicates that she's received a notice from the bank and the mortgage payments have not been made. And at this point, what information would you like to know to try to assist her or to see what her options are at this point?
And you can just answer that question in the chat box on the right, and I'd recommend just in the drop-down menu where it says Send To, if you could select Sending to all participants, then we can all read them together. Or I guess it would be all, yes, all participants.
Okay, so we have someone who said, is the loan in default? Is there a cosigner? How far behind is she? What are her chances for catching up? Someone else has requested that we would need a copy of the deed of trust. Is her name on the loan? Can she afford the monthly payments if she does get caught up? Is she on the note? Good. That'll come into play later. Is she on the deed? Who normally has paid the mortgage? Are there copies of the check? Does she have a way to pay it? Is her name on the mortgage on the promissory note? Is she living in the house? All right. Sort of slow down. So I think that's probably got everyone's responses. Yep, those are all really good questions. A lot of folks have started to hit on some of the key points that I'm about to go into, so it sounds like you guys are right on track with me. The first thing I want to make sure you understand is kind of the who is who in a mortgage transaction. There's a lot of different players with different responsibilities and different levels of contact with your client or contact to the transaction. And so I just want to go through these terms just so you have some sort of idea of what's there. Many loans, especially if they were done sort of during the subprime boom during the 90s and 2000s, were originated by a mortgage broker. You can kind of think of a mortgage broker a little bit like a real estate agent, that at least in theory a mortgage broker was supposed to take your client's application for a mortgage and go and find various mortgage products and get them signed up for one of them. Many homeowners were under the impression that the mortgage broker would find them the best product, which we now know was not really happening. But that's often the person who did all of the upfront paperwork to get the financing in place, and who then very often is probably not around anymore. We usually also have an originating lender. Oftentimes they are not still in the picture. Either they've gone bankrupt or they've sold the loan on. If you're familiar with some of the big mortgage companies, you know, AmeriQuest did a lot of loan originations before they died. Countrywide did a lot of loan originations before they went into Bank of America. There may be all sorts of different banks on the original mortgage documents that are not in the picture anymore. Often because those lenders then passed or sold the loan to some sort of assignee or investor. A lot of times, especially in the subprime market, these loans were pooled together in securitized trusts. That's where we got in all that, you know, CDO stuff that you may have heard about during the foreclosure crisis. They also are often investors. You know, often Fannie Mae and Freddie Mac are referred to as investors on this loan. Those may be terms that you've heard. Fannie Mae and Freddie Mac being the government-sponsored entities that do a lot of financing in the mortgage market. The person or the bank that your client is going to know is the servicer. And that is the bank or company that is doing the day-to-day, taking the money, making the collection calls, dealing with the foreclosure and the modification. So those are going to be, you know, your Banks of Americas, your Wells Fargos, and those kind of places. Sometimes loans have insurance on them. One of the popular programs is the FHA insurance program through the Department of Housing and Urban Development. The VA also has an insurance program through the Department of Veterans Affairs. There's also PMI insurance, which is a private insurance product. Sometimes states have their own insurance products as well, or have their own housing mortgage programs that are going to be state specific. You might also see references to this entity called a Mortgage Electronic Registration System, or MARS, which is essentially a database of loans that was set up to track assignments and transfers of ownership and of mortgages. That got its own issues. Whether MERS can do something varies state to state, but it's a name that you might need to be aware of, because it's very likely that you'll see it in some of the mortgage documents that MERS is acting as the nominee for the mortgage company and may, in some states, have some rights to foreclose. Mortgage servicers are generally quite large. As you know, the mortgage companies like Bank of America and Wells Fargo own considerable amounts of the market share. And because they're so large, most of them are quite divided into different departments. The customer service, collections, loss mitigation, foreclosures. Often there will be an escalation department above some of those departments. So when you're working, you're trying to assist a survivor, one thing you're going to want to do is try to get to the department that is going to help you. If your client is behind on her mortgage, most of her calls are going to get routed into the collection department, who is not going to do a whole lot except demand money. So you need to know to get out of that department and try to get into the loss mitigation department, which is really the department that can usually do something to assist you. There's a question that, will a mortgage company speak to her if she is not on the note? And that is a big issue. Most of the mortgage companies are taking the position that if she's not on the promissory note, that they cannot release information. And we're going to get into some more detail on the differences there and a few ideas to try to deal with it. It's a big problem, and we don't have a good solution on it, but we'll go into that in some more detail in a bit. This does lend itself to the next question in the next slide about the documents. And if any of you have ever looked at a closing packet or have closed your own home loan, you know that there's quite a stack of documents there to go through. And some of them are fairly silly, things like, for a while we were doing a Patriot Act disclosure. you know, that really don't have a whole lot of substantive detail to them. So here are some of the big things to look for when you're trying to look through these documents if your survivor has been able to get her hands on the packet. You need to locate the note, because that's going to have the terms of the loan itself, you know, the interest rate, payment due, how long the mortgage is for. Is it a 30-year mortgage? Is there an adjustable rate? Those kind of things are all going to be in the note. And that's the document that creates the actual loan. That's the document where I say, okay, okay, bank, I am going to borrow $120,000 to buy a house, and I agree to pay you back under these terms, okay? The mortgage is a second document, and it's often quite longer. It's usually 22, 25 pages on the newer mortgages, whereas the note's usually 3 to 4 pages. The mortgage has a lot of meat to it, and while it's not the basic obligation of I borrow money and I will pay you back, it's all of this filler about escrow accounts, defaults, all sorts of things, and most importantly, it puts the lien on the property, on the house, that they can then foreclose against. And it's important to know, as some of the questions alluded to, which documents your client has signed versus what documents the husband or the other homeowner has signed. Because it's a very common position that both spouses may have signed the mortgage because they're on title to the property or the real estate, but the only one spouse has signed the note. And there's lots of reasons for that. Sometimes it's credit score, sometimes it was just broker convenience, you know. Sometimes it's an element of abuse that the abuser likes to own all the property and have control over the property but not actually be personally responsible for any of the debt to the property. But regardless of the reason why you got there, you need to know if your survivor is on the note in the mortgage, just one, or none of them at all, if this was something that was done before the relationship began. Or if she just wasn't put onto it, sometimes it's an element of the abuse. There might be other information in that closing packet that can be useful for you, especially if you're, you know, getting into property settlements and debts and who ate up equity in the house. One thing to really look for is at the HUD-1 settlement statement, because that will show all the disbursements of the loan. So say you have a situation where the wife comes into the marriage with a property you know, that she inherited from her mother, let's say. And during the course of the marriage, she and the husband have financed the property and taken a whole lot of money out of it. But she doesn't know where that money went to because he was using it to pay for his debts or his things. And now the house that she owned free and clear is now quite encumbered. The HUD-1 may be able to tell you what debts he paid, were those separate debts, how did that money get used as you're sorting out your property settlement. In a judicial foreclosure state, the lenders, again, have to file a lawsuit in order to foreclose. The lawsuit is filed against the borrowers and those who signed the mortgage to establish the default amount, which, to put it simply, is usually the balance due on the mortgage loan plus whatever fees they've added. And then they ask for the court order that the home be sold and the proceeds be applied towards that debt. Assuming the court finds that the debt is valid, is in default, then it can issue the judgment for that amount and they can go ahead and move towards the sale. Some states allow deficiency judgments. That is, that if the house doesn't sell for the whole amount that is due in owing, are they liable for the rest? Some states do not allow deficiency judgments. So that's a place where you'll have to double check your state law. For instance, California, although it's a non-judicial state, they've got some laws that if it's the first mortgage that was used to purchase the house, there can't be a deficiency judgment. So again, check your state law. Non-judicial foreclosures, again, are based on that deed of trust or mortgage has a power of sale clause, and that power of sale clause allows them to proceed without getting a court order first. the procedures vary quite differently in terms of the notices that are required. Just as an example, in my state, in Michigan, there is a little bit of a pre-foreclosure process right now, but it's temporary. But our fundamental process is they just have to publish the sale date in the newspaper for 4 weeks and post it once on the property in order to be able to sell the property at a foreclosure sale. So it can happen quite quickly in some states, and there's not always a lot of notice or process that is required. In most of those states where they do a non-judicial foreclosure, if there is a deficiency that they're allowed to collect, they would then at that point have to file a lawsuit. For those of you who are wondering how to find someone in your area doing this work, a lot of legal aid offices have started foreclosure prevention projects in light of the foreclosure crisis. So I'd encourage you, if you're not with a legal aid office, to go see if your local legal aid has such attorneys. And I recognized a few names on the list, knowing that they have some foreclosure attorneys running around their programs. Or if your legal aid is not doing it, or you want to connect with some private attorneys, if you have a client who's not eligible for legal aid, I'd recommend that you could look at the attorney members of NACA, the National Association of Consumer Advocates. I will say consumer advocate attorneys are quite friendly and they like to help. So most of them will be more than willing to answer your questions, and some of them know me, so feel free to invoke my name if you think it will get you somewhere. And I think now would be a good time, if anyone's been holding on to a question, if you would like to raise your hand or put it in the chat box and we can answer some of those. Okay, I'm not seeing anything, so we'll just go ahead and move on. Again, please feel free to ask questions while I'm talking, or I'll try to stop every so often to give you an opportunity to catch your breath and ask a question. So now it's my turn to ask a question of you. So after reviewing your paperwork, it seems that your client's not getting proper notices and hasn't been getting notices from the very beginning of when the mortgage loan was first closed. She's been dealing with multiple banks, and she's confused about who in the world she's even supposed to be dealing with. And she also thinks that her husband might have worked out some sort of modification, but no one seems to have any records of that anywhere. So if you have any ideas, go ahead and put them in the chat box about are there any sort of claims or legal issues that you'd want to investigate at this point? Is there a difference in those claims if you're in a judicial foreclosure state versus a non-judicial foreclosure state? And is there anything else here that you would want to be concerned about, or opportunities for advocacy regarding her safety and specifically as a survivor of domestic violence? Okay, one commenter has said he's in a judicial foreclosure state, so he's wanting to jump right into discovery, requesting the records of the lender, the servicer, and that he sees possible estoppel claims. And I think that's a great point that, and we'll discuss a little bit about getting documents later, that, when you're in a judicial foreclosure state, you've got that discovery mechanism, kind of right away in most courts. I know some courts attempt to limit discovery from the outset, but most courts allow pretty full discovery on mortgage foreclosure cases. Yeah, and that same commenter said in his experience, if there are multiple transfers of the obligation, they can seldom provide the chain of title to the note or even produce the originals. And that's been a successful defense in many of the, especially judicial foreclosure estates. Okay. Well, I'm going to go ahead and move on. I must say it's always so hard with a webinar to know if this is all making sense or not to you, because I can't see faces. So please do feel free to speak up and ask questions, because I want to make sure that this is all valuable for you. Okay. So when we're looking at foreclosure defenses, and I use foreclosure defense both, when you're actually defending the judicial foreclosure action, as well as in order to stop the foreclosure, you have to go to court and affirmatively file a case, since there is no judicial foreclosure to get involved with. You might have defenses related to the origination or the making of the loan. And just to give you some kind of buzzwords to store away, or those of you who have done this work, I'll probably start nodding along. They could be claims under the Truth in Lending Act. A lot of those claims have to do with disclosures, and if the disclosures were given appropriately, if they were accurate, as well as the Homeownership and Equity Protection Act for higher cost mortgages. There's limitations on some terms. There's some additional disclosures. One thing that's really useful with the Truth in Lending Act is in some transactions, when it's a refinance of the principal residence, if disclosures were not given properly, there is an opportunity, depending on your timeline, to rescind the transaction, to basically set that aside and kind of restore everyone back to where they were. And that can be really useful to evaluate if you have that in a domestic violence situation, because so often if you have the abusive partner controlling all the finances, he may be out doing these loans and taking out these mortgages, and she may very well not be getting the correct disclosures because she's being isolated and held apart from that transaction. And so I think that's a really interesting claim to look at in light of that kind of domestic violence. There might be other federal statutes. RESPA is the Real Estate Settlement Procedures Act, which governs a lot of the forms, escrow accounts, a lot of those kind of things. And then depending on your state, there may be state law claims. If you have a state law that looks to regulate predatory lending, common law claims going to fraud, misrepresentation, and conscionability. Again, depending on your state, if you have a state UDAP, which stands for Unlawful and Deceptive Acts and Practices Law, there might be something useful there if you're looking for claims against the mortgage company based upon those kind of actions. Again, how far you're going to be able to get with that and whether it will apply will depend on your state law. You might also have issues related to the servicing of the loan. So not issues related to how the loan was made, but what did they do after this loan was completed and we got into payment. We have found a lot of payment application problems with mortgages. For example, I had a client who tried to catch up on his mortgage and he mailed them a $6,000 check, which they promptly they lost, essentially. That they couldn't find and they didn't apply to the account, and it was kind of a disaster from there. So if it sounds like payments are being made, but yet the loan is showing in default, there might be a problem with how the payments are being handled. Forced to place insurance issues, if the homeowner has homeowners insurance, but yet the mortgage company is still buying insurance on their behalf. Other inappropriate charges. There's been a lot of problems with loan modification and loss mitigation agreements. Specifically, they get into a, either a temporary payment plan or the trial payment plan under the Hamp program, which we'll talk about in a little bit, and it never becomes a finalized loan modification. Or I've had numerous clients who have signed a loan modification, thought it was finalized, mail it back for making payments, and then for some reason it goes off the rails and the mortgage company isn't honoring it. That's unfortunately very common. There might be other claims related to the contract, promissory estoppel. The one commenter brought up estoppel, breach of duty of good faith and fair dealing, those types of claims. Okay. There also might be defenses related to the foreclosure proceeding itself. That the loan it's not really in default, which in some ways goes to the missing payments and modification issues, that they didn't do the notices to properly accelerate the indebtedness in order to foreclose. Issues of standing, and the other commenter noted this, that who owns the note, who owns this indebtedness, who is the appropriate person to be, or appropriate entity to be pursuing this foreclosure. The industry is paid very kind of loose and fast with the paperwork, and it's quite often that the paperwork is not in line. I will caution that that's an issue of state laws. In some states, that defense is working very well and truly halting in foreclosures. In other states, like in my state of Michigan, this is by statute, actually, the servicer can foreclose in its own name. So again, it's something, before you get too excited there, make sure you understand your state statute. There's sometimes other defects in the foreclosure process. A lot of states and some localities, Philadelphia is coming to mind, have negotiation or mediation procedures that must be followed. Some judicial, as part of the judicial process, some outside of the judicial process. And so it's good to know if you are going to be looking at that and have an opportunity to participate in that process, because sometimes they do work. I know Michigan's process actually we found to really be a good process that is giving us some loan modifications in cases where we weren't able to get through to servicers. So again, I would encourage you to figure out what's available to the homeowners in your area. I do see the question there, just to let you know. I'm going to get to that in a minute, but I don't want you to think that I'm ignoring your question there, okay? All right. Again, I'm not going to talk about this too much because I think we're starting to get about halfway through, and I think some of this is more interesting than others. But just know if you're in a judicial or non-judicial state what your procedures are going to look like. If you're in a non-judicial state, we often have to get injunctions. And just also be aware of your statute of limitations on claims. The Truth in Lending Act has, if you're looking at a rescission claim, does have a hard and fast 3-year limit that cannot be extended. So just know those things as you're going through, and if you think you have a possible claim, you just want to keep your eye on that statute of limitations clock. A lot of the consumer statutes have very short statute of limitations that you can blow through pretty quickly if you're not paying attention. Bankruptcy. I'm not going to talk a lot about bankruptcy, but I think that you just need to know it's there and it's available. A Chapter 13 bankruptcy is kind of a payment plan kind of bankruptcy. And for someone looking to keep a home, that's generally what they're most often going to look at. It gives you an opportunity to halt the foreclosure process and to present a payment plan to then catch up on those missed payments. And in the event that the homeowner is underwater, that they owe more on the house than it's worth, and there's a second mortgage or sometimes even a third mortgage, sometimes you can what's called strip that second or third mortgage depending on the equity and how far underwater they are. The one problem with a Chapter 13 bankruptcy or with bankruptcy courts is that unlike some other kinds of contracts, the bankruptcy court does not have any jurisdiction or authority to modify the first mortgage on a primary residence. And so you're looking at the situation that in order for a Chapter 13 payment plan to actually work and to do what you need it to do, you've got to have money. And you have to have money to cover that monthly payment plus a portion of the past due and some of the other debts and bankruptcy fees. So it's not it's not going to be useful or work out well for someone who's had a reduction in income, which you do often see with the breakup of a marriage. But it's an option that can perhaps be useful. The Chapter 7 bankruptcy is the one that most people are very familiar with, and that's the liquidation kind of bankruptcy, where the debtor does not have a lot of income. There's a means test that they have to go through, and they can discharge the unsecured debts, so things like credit cards and medical bills, debts that are not attached to property. If you want to keep the piece of property, then you still have to pay the debt that's attached to it or make arrangements. However, that might be useful for someone who's on the brink of foreclosure, is that if they can do the Chapter 7, and wipe out, say, the credit card that's been garnishing their paychecks, so then there's not enough money to pay the mortgage, sometimes you can bring the budget into line and clean out some of that stuff off the budget to then be able to make a good mortgage payment and be successful with the mortgage. So sometimes it can be very useful in those situations. And again, when we're dealing with survivors, I know very often the batterer is often taking out credit with the survivor as the sole debtor, as a co-debtor, and so it may very well be that she's on the hook for all these debts that he's run up, and sometimes really the best way to clean those out is to do the bankruptcy, either to save the house or otherwise. Okay, I'm going to go back. The only question, if anyone has a question, feel free to type it. Again, the one question I have, I'm going to get to in a couple minutes because it asks about that the client doesn't have the ability to make payments, but what options, if any, might be available to her, and that's going to be kind of the next part of my discussion. So if we have any questions on some of these legal issues or defenses or procedure, now would be a good time to ask if you have them. Okay. Well, hopefully it's making sense so far, or at least enough sense that you're following along. Okay. And this is, again, going into Katie's question here. Your client has decided she would like you to advocate for her to prevent the foreclosure and would like to know what her options are. And so the questions I have for you are, what are the options that you think she might have at this point? And what more information would you need in order to assist her and otherwise help her assess those options? All right, I have someone who said walk away. Yes, there are certainly situations where that might be the most appropriate thing to do. Someone else has mentioned a short sale. A short sale, I probably described one of the slides, but just for you that are unfamiliar, is where you sell the house, but you negotiate with a lender to pay less than what is owed on the mortgage for the short sale. In a lot of those cases, they will forgive the deficiency, although not always. Someone else has said if there are divorce proceedings going on, if she can pay, if she cares about her credit or even has any credit, that's good to know. Someone else has said cure the default, do a Chapter 7 bankruptcy and reaffirm the debt, or a Chapter 13 plan. Someone else has mentioned a deed in lieu. Someone else has mentioned possible defense of FHA or other governmental requirements prior to foreclosure. That's a good point, and I'm actually going to stop here and address that. The FHA loan insurance program that is done by HUD does have, by regulation, a number of steps that they are supposed to take in order to prevent foreclosure. They're required to give a notice within so many days of default, offering an opportunity for a face-to-face meeting, and they're supposed to go through what they call kind of a waterfall of options that actually is in process of changing. The change is supposed to be effective in February. And in many states, if the lender fails to comply with those FHA requirements, it can be a defense to the mortgage foreclosure. Thank you very much, Ted, for bringing that up and making sure I mention it. I'm unfortunately in a state where the FHA defense is not really a recognized defense, but in some cases, in some states, Ohio, Virginia, they're having really good luck with enforcing those FHA regulations, and so they might be useful. Okay, good, great. Thank you for those who are participating. Okay, this process is known as loss mitigation. And one thing to remember is that loss mitigation is the bank's term, and it's to mitigate the bank's loss so that they don't lose money on the loan versus the homeowner mitigating their loss of the house. And so in some ways you want to understand that that's the way the bank is seeing the situation, is where are they going to be able to save money. Now, they don't always rationally process things that way, but that's sort of how this loss mitigation idea was initially set up. And there's basically two groups of options. There's those that will allow the homeowner to keep the house and those that don't, okay? Kind of makes sense. One thing you need to know, and I think someone mentioned this in their comments, is that you need to know more about the income situation. Are we dealing with a short-term or long-term change? So, you know, in a divorce situation, very often there's going to be a decrease in income because, you know, we're removing the spouse from the house, and, you know, so we're only going to have one income, although we'll talk about child support and the like in a minute. So that tends to be a long-term change unless we have a survivor who either has her own job and it's a good job and she doesn't really need his income. We also have those situations where she really was the primary breadwinner and he wasn't. Or, you know, sometimes they have the capacity to get some income or some employment quickly where it's more of a short term. Most common, the short-term income situations I see are things like there was an illness where they can, where, you know, it's short-term. They were out of work for a couple of months. They had a lot of medical expenses, but now that's kind of passed, and so they're back to work, and we just need to maybe deal with those couple of months that are past due. Okay. And that's where you have to have a good, honest conversation with the homeowner about what's really going on with the income, what are really the possibilities. I had an 80-year-old homeowner who had never worked a day in her life because of her disabilities, who was trying to convince me she would go and get a job to replace the lost income. And it just was not practical that this woman would ever be able to get a job, especially in Michigan's economic environment. So sometimes it's going to involve challenging your client about kind of the reality of the situation. Your options will vary somewhat depending on who you're working with. You know, whether it's an FHA loan versus a different kind of loan, who the investor is on the loan. One thing to know is kind of what we sometimes call the loan-to-value ratio, or is essentially it is how much is the house worth versus how much that is owed. Under the current loan modification models, it's much easier to get a loan modification if you are upside down or if you owe more than the house is worth. Those homeowners who are sitting on some substantial equity are going to have a much harder time getting a loan modification and getting that lender to work with them because, quite frankly, the lender is going to do just fine if they foreclose. You also need to know how far behind the borrower is on payment, so you know how much debt are we looking at here. It's always best to try to do as much of this if you can before we're in the foreclosure and have those court dates or sheriff sale dates looming. But you can sometimes pick this up and anywhere in it. And I try to say, you know, even if you're really close to a sale, it doesn't really hurt to pitch in and see what you can be done. It's pretty rare, I say to my other attorneys, that we can make the situation worse. And sometimes you have to go in and just give it a good try and see where you can go, because you don't know unless you ask. All right. I do have a comment from someone in California that they've been successful in asserting, I think she's alluding to the FHA defense, on post-foreclosure eviction cases, in San Diego at least. So good. I'm glad that's working there. Okay, and then I have another question, but I think I'll get to that in a minute. And I already talked a little bit about the long-term versus short-term crisis, and again, being honest and reviewing that budget carefully, and making sure that we're being truthful about those numbers and what's really a possibility. So some of the options are a special forbearance. You often see this in FHA loans, and this is to deal generally with a short-term crisis, that we allow a suspension or a reduction in the payment amount for a period of time to get through this crisis. And then once the crisis is over, then we have to then deal with the amount that's past due and look at either catching that up or dealing with that in some way. So it kind of gives folks some breathing room, hopefully keeps them out of an active foreclosure during that time. We sometimes do see repayment plans where, again, you usually have those in a situation where whatever crisis that it created, the missed payments, has been resolved, but we need to deal with those months that weren't paid. And so, you know, they usually just kind of break them up over a couple months. Generally, I see like 6 months as those. I did have one that actually went into years, but it was sort of a special case. But again, you have to have someone who not only has enough income to do those monthly payments, but is going to have that extra to then pay the extra. It is a little cheaper to do it this way than to do it in the bankruptcy. But if they can afford this and the mortgage lender won't pay, you can look at doing that Chapter 13 bankruptcy. I know we have a lot of rural grantees on the phone. And so while I'm not going to get into all the intricate details of the rural housing programs, do know that the Rural Housing Service or Rural Development Department of the United States Department of Agriculture does do a loan program. There's actually 2 loan programs, those that the USDA does itself and does all of the servicing on, and those where it's more of an insurance program, the guaranteed loan program, where it's a private servicer like Bank of America or U.S. Bank or someone like that. On those direct loans, the ones that the government is servicing, they do have something called a moratorium, that if there's been a sufficient income reduction, it allows for an up to 2-year break from payments, which can be really useful. So again, those of you who are practicing in rural areas, you might want to brush up on these programs because they're pretty unique, and they're not going to have a lot in a lot of the mainstream foreclosure resources. If you have ever heard of him, Gideon Anders at the National Housing Law Project is sort of the national expert on the rural housing programs, and the National Housing Law Project actually has a book available that goes into those 2 loan programs in some detail. Many states also have the Hardest Hit Funds program. Those are funds that were coming from the federal government out of the TARP program, which was that bailout back in 2008. And so a lot of states have developed programs with rescue funds, assistance for unemployment recipients. So it's good to know if your state has one of these hardest hit programs, and if so, what are the eligibility and what are the options available. I know the Michigan program has been, it hasn't addressed everything, but it's been a really great tool in some of our cases that have really, it's been a fantastic solution. Yes, so there's a comment about the RHS programs. Yes, the 505 loan servicing options are great. They do save homes. Yeah, the direct program is pretty good. That moratorium is. The guaranteed program that deals with private servicers, in my experience, has got some issues. But since it is rather peculiar, I'm not going to get into a whole lot. But again, those of you who are working in more rural areas and who need more information on that, either contact me privately off the webinar, and I would be more than willing to share everything I know with you, or go ahead and look at the National Housing Law Project materials. Okay, loan modification is mostly what most people need and what most people want. This is the big deal, that you are adjusting the terms of the note, of the actual loan, to deal with those past due payments and make the payment affordable going forward. Okay, so these are often going to be the cases where there has been some sort of financial problem that is long-term and a decrease in income, and you need to do something to make this payment sustainable. Some of you may have heard of the Hamp Program, which is sometimes called the Obama Plan, that came out, was an addition to the Wall Street bailout under TARP, TARP being the Troubled Asset Relief Program. There's also been in the news recently the Attorney General's and Department of Justice settlement, which was with the big 5 mortgage servicers, the Bank of America, Chase, Citi, Wells, and GMAC, that is requiring some loan modifications, especially with Bank of America, because Bank of America has some additional and more significant obligations under that settlement. They all have their own rules and their own eligibility. Hamp has a Tier 1, has a Tier 2. A lot of the investors have programs. For example, Fannie Mae has its own modification program that's an alternative to Hamp. So there's lots of programs out there. Some of them, such as Hamp, have really accessible guidelines, so you'll be able to find those guidelines and get some sense of whether or not your client might be eligible for this. Other ones are kind of internal and don't have publicly accessible information. So if you have a client who is looking at a loan modification and you are not personally familiar with it, that's when pulling in a good foreclosure attorney, or if you've got a good certified housing counselor. HUD has certified housing counselors. A lot of states have a good network of those. That might be a really good resource to pull in, because they will have kept up on the different programs and requirements and how do you submit for these things. For those mortgages that have insurance, there's sometimes a partial claim available, which is basically kind of an insurance payment made early. Oftentimes, they kind of put like a second mortgage on it to cover the insurance in advance. You don't see them a lot, but there's something available. Okay, if you've got a homeowner for whatever reason, either she doesn't have the money to do any of those things, or she's just decided she doesn't want the house, which happens. These are some of the options for if you don't want to keep the house or you can't keep the house. Just doing a pre-foreclosure sale. If you have someone who's in a good position in terms of the loan amount versus the value of the house, they might be able to just do a sale as a normal sale. And if they're doing a sale at that point, if they actually have equity that the house is worth more than the loan, they'd be able to keep that equity. In this market, that's pretty rare anymore, although it does sometimes happen. More often, folks are looking to do a short sale, where the homeowner needs to sell the house for less than what's due on the loan. And the mortgage companies have process for how you do this. You don't just get to do it. Most of them are going to want to see the property marketed by a licensed realtor. Most of them like to see that you've started the price, the sale price, at something that would cover the loan, and that you're trying to market the property, but it's just no one's making offers, and then you decrease the price accordingly. It's not something that a homeowner can generally do on their own, because they don't generally have the ability to market it in the same way as a realtor will. There are also situations where either they can't do a short sale, they're just not getting any offers no matter how they drop the price, or other circumstances where they want to do a deed in lieu, which is basically the homeowner signing the deed over to the mortgage company and just giving them a house instead of requiring them to go through the foreclosure process. As Ted has pointed out, there might be a statute of limitations issue here. In both of these, in the short sale and deed in lieu, there's something still owing on the mortgage loan. And so then the question becomes, does the mortgage company forgive that? Are they just going to wipe it and let it go? or are they going to seek payment for that? Which is the same issue after a regular foreclosure sale as well, is are they going to seek payment on the difference or on the deficiency? If there is a deficiency and the mortgage company still has the right to pursue that, they can be facing potential collection action on this down the road. And how long they have to collect it is going to depend on your state laws. In Michigan, you have 15 years to foreclose on a mortgage. And so if someone defaults now, they potentially could be foreclosed on at any time in the next 15 years. If for some reason the mortgage company doesn't do it right away. But on the notes, there's generally a different limitation. In Michigan, it's 6 years for most notes. And so it's a good thing to have an idea of are they going to be on the hook for this thing even post-short sale, post-foreclosure, and how long are they going to be under that threat? And is that deficiency something that we need to deal with within the family law case context? In order to apply for these things, you usually have to put together a loss mitigation packet, which includes these type of things: the budget, some authorizations, some other disclosures. They usually require a letter of hardship to document what has happened such that you got behind. This is oftentimes to address the issue of the popular misconception that people are just defaulting on their loans to get a better payment, which the mortgage companies don't like. But instead, they generally require you to write a letter and document that you're going through a divorce, you've lost income because of unemployment or something like that, to document that it's not your fault, you're behind on the mortgage. They usually want tax returns. The 4506T is the IRS form to request tax returns. Sometimes they'll just let you sign one of those so they can get the tax returns directly from the IRS, and bank statements. Now here's where it's going to get tricky when you're representing survivors, is if the batterer or the husband is on the loan, you might need his cooperation to sign off on this part of the process, especially if the divorce proceedings are not finalized and we don't have a clear court order about who's getting what property, or in those situations where the parties were never married, but yet they co-own this property. So what I am telling you, and my best advice, is to be prepared with a plan about how you need this process to go, what you're going to need from him, what level of cooperation, and how can we accomplish those needs and meet those needs without allowing this process to become another way for him to abuse her. That he's going to withhold giving her copies of tax returns unless she does X, Y, Z. And to have some plans and some protections and to do that safety planning to protect her throughout the process. And we'll talk a little bit more about some of those more specific issues in a bit. The big issue with the loss mitigation, especially if you're looking at a loan modification where you want to try to keep the house, is you have to show the capacity to make those payments given her current financial status. And that she's going to be able to make and be able to sustain those payments. I'm going to go back to Katie's question here, that she's working on a divorce case where foreclosure has been an issue. The client has not had the ability to take over mortgage payments but wants to keep the house, and so is asking, is she out of luck or is there anything else that can be done? And hopefully, Katie and others, this will give you some framework and some guidance as to the answer to that is maybe. It's going to depend on the individual circumstances, but there are some options that can be explored to see if there's something that she's going to be able to do in order to keep the house, or if she's going to have to look at one of those options in terms of walking away from the house and how to do that. Okay. Who helps with loss mitigation? Again, thank you, Katie, for your comment. Who helps with loss mitigation? Again, a lot of local services offices, legal services offices, have ramped up their foreclosure programs in light of the crisis, and they may have attorneys who you can coordinate with. They might just be down the hall, or you might need to figure out who those folks are. HUD does have a national network of housing counselors. That's the phone number for HUD. Those counselors are generally all certified, and they're all nonprofits, so they are free, which can be very helpful for someone who's going through a financial crisis, that they can get some free qualified help. A lot of those also have gone through the NeighborWorks certification program, which it has some of its criticisms, but overall, you know, generally, for most intents and purposes, is decent. I know my state has a state network and a state certification process as well that I think actually holds them to a higher standard than HUD. So you might look at resources in your state for housing counselors. I will warn you, in case you have not ever been home in the afternoon to see the wonderful ads on daytime TV, that there are a lot of rescue scams. A lot of folks saying that if you pay us X amount of dollars, we will get you one of these Obama plan modifications. We will cure your mortgage, you know, making all sorts of promises. And we've sort of found, I don't think in any empirical way, but anecdotally at least, that survivors are falling prey to these scams in an effort to save the house. And so they're paying over thousands of dollars to these outfits and then losing the house anyway. So I would encourage you that if you are seeing these scams, that you promptly report them to your Attorney General, the Federal Trade Commission, and the Consumer Financial Protection Bureau. They almost always have online complaint forms to do that, and most of those agencies have been quite active in trying to shut these places down so that they can stop preying on people. Okay. All right, so I think I'd answered all the questions that have popped up so far, but if you have a question, please feel free again to continue writing it in. You're a little bit of a quiet group, but it may just be the technology. It's sometimes hard to interact on this technology, or maybe you're just on Facebook. Okay, so I'll give you a minute or two to write some questions. And while you're thinking of questions, I'm going to also ask you another question. Your client is concerned that when her husband finds out that she's working to try to keep the house, that at a minimum he's going to refuse to assist her, and that he may even become more violent as he realizes that she's undertaking this without having to rely on him and depend on him and basically let him control the show. So what are some of the things you can do to try to require or ensure his cooperation? And are there any other issues that you see or things that you can do to try to keep her safe in terms of safety planning? Whoops, hold on. Let me go. I just closed the box I needed to see. Okay, there we go. All right. So we have one commenter who says, in the unlikely event that he's rational, explain to him he'll have the entire debt if she discharges her obligation in bankruptcy. You need a safety plan, possible protective orders. And that is a good thing to bring up, and I'm glad he raised this point, is that that it makes sense that to the extent that you are working with an abuser and having to deal with a batterer who is fairly conscious of his own self-preservation and is willing to think in those thoughts instead of, abusing her no matter what the cost to him. And you all know they, come in various shades. For some abusers, that does make sense. That if you say, look, she's willing to keep the house, if you can just give me these couple things, then she's going to keep the house. There's not going to be a foreclosure. Both of your credit ratings are going to be okay, and nobody's going to be haunting you for this debt for the next 10 years. Some guys get that, and it makes sense, and then they're willing to participate. And yes, dealing with protective orders. Make sure any secret address is not in documents submitted, and that's another good point, that if they're both on the loan, they're going to both have access to that. And I've seen, one bank, actually a friend of mine who's been going through a domestic violence situation and had a secret address for a while. She changed the address on her personal separate account, but the bank carried over the address change to the mortgage account and then started sending notices to the new address. Unfortunately, we were able to go to the local manager and get that computer glitch fixed, but it's something to be aware of, and it might be a good idea to think, okay, where's the safest place to get mail? Do we want the mail for these bank accounts and mortgage loans to go to the attorney's office? Do we want to set up a P.O. box at a public post office to get the mail so we don't have to worry about disclosing the safe address? There is a comment, if she gets divorced in the judge's deed, she doesn't need his permission to do anything with the house, which can be true, but can also be a little more complicated than that, and I'll get into that in a minute. So great, thank you, some great comments there. I'm looking at the time, so I'm going to actually start to go even faster than I have been. So in terms of safety planning, I would recommend, know the batterer, partner with that survivor to identify the risks. She is in the best place to give you the information of how will he react to things and what is he most likely to do if he's asked to participate, if he needs to sign something, if he even finds out that she's trying to keep the house and to do this. And so she can help you, how will he identify, or excuse me, how will he react? Are there going to be warning signs? So you can better help her with the risk assessment of how much is the safety going to become an issue and whether those safety issues are going to impact whether or not she even wants to go down this road. Which leads to the next point of sometimes you need to discuss with the survivor that it's okay to leave the house. That you often see with survivors that in the midst of kind of everything else falling apart, that this marriage is ending, that we're now fighting over the kids, and now, maybe as bad as the violence was, maybe there was at least enough economic stability that she at least felt safe knowing that there was a roof over her head in that sense. I've seen survivors who want to hang on to that house at all costs because they feel like it's kind of what they have left out of all of the chaos that's swirling around them. And so sometimes we need to have the discussion that it is just a house and that it's okay to move on and to give her that, emotional support and, that legal knowledge of you can move on, and if you move on and you decide to leave, here's what that would look like. Because sometimes, it's just not possible or it's just not a good idea from a safety standpoint. If she wants to keep the home, again, you need to make sure that she has the capacity to pay for it. And that may mean, looking at your spousal support or alimony claims, child support. Are there other government benefits she can access? Is she eligible for disability or SSI? Can she possibly rent out part of the house, take in a tenant to help cover the costs? In some states, she can do a deferred sale of home order where basically they put it in that she'll maintain the house for X number of years and then at that point sell it. You may need to help her access employment resources, especially if she's been out of the workforce for a while because she's been the one staying home raising the children, accessing that kind of support. You can then look at using the family courts to order mortgage payments in lieu of spousal support. For some reason, sometimes that goes down better for some folks, that they're paying the mortgage and not alimony. That does have some tax consequences, that if he's making the mortgage payment, that's generally not tax deductible in the same way alimony payments might be, so that may be a consideration. It also, it's one of those things you have to kind of know your family and your situation that you're working with to know whether spousal support is going to play better both with your judge and with your opposing party, or if you want to go the other way. We've had success in ordering the family court to order cooperation with loss mitigation, that he has to turn over bank statements, that he has to turn over tax returns, that he has to cooperate and not obstruct that process. And then if it's a court order, you can have whatever contempt powers at your to be useful in trying to enforce that. One thing I will say, and one person sort of mentioned the judge's deed, and I read that comment, is that a judgment of divorce under many state laws is often sufficient in and of itself to transfer real property. I know in Michigan, if you just throw in the property description, you can file it with our Register of Deeds who maintains the property records, and that can act as the transfer. That's not always acceptable in the mortgage industry. Sometimes they're working kind of under a different set of standards that require more than what the basic state law requires. And so a lot of times you're going to see the mortgage company asking for an actual quitclaim deed, which you can either sometimes do as a judge's deed in those states that have that, or my attorneys here, now that we've addressed this problem by, if they know he's going to be at the final hearing, they bring the quitclaim deed with them and have the judge say, you know, basically you're not leaving this courtroom until you sign that quitclaim deed. And, you know, because if you can get him right there in the courtroom, he's going to have a much tougher time getting away than if you're trying to chase him a couple years down the road to get this quitclaim deed to make Bank of America happy so that they'll talk to your client. Selling the property. If they co-own the house, she again will either need a court order giving her permission to sell the house without his permission, or she's going to need his permission, and he's going to have to sign the sale documents. And again, just a note here, if the selling price doesn't cover the mortgage, what are we going to do with the deficiency? Either if you do the short sale or if it goes through foreclosure, and probably a good idea to address that in the judgment of divorce, as well as make sure she understands the ramifications there. Here's a list of some other ideas. Some of these are going to work better in some states than others. In some states, and I believe California is the best model and the best state to look to for this idea, is the idea to bring a motion to join third parties, to basically pull the mortgage company into the divorce and have the court then order them to do or to not do things, you know, to not foreclose. It's a really a creature of state law. It's very creative, I think, and again, I think it's mostly the California advocates where I've heard of this idea from, but it might be something to consider if you want to pull that case law and decide how much you can import into where you are. Again, the motion's compelling signature, looking at temporary restraining orders, either in an independent case against the mortgage company, or if you need to do something within the family law case to get, you know, the husband or the batterer to do something. Looking at the court-ordered sale of the home, especially, again, if we have a batterer who's refusing to cooperate with short sale type efforts. I'll talk about the partition action. In many cases, we have non-married partners who co-own property. And so a lot of my comments have been really dealing with the divorce situation because, quite frankly, it's easier because you've got a court there with jurisdiction to look at the property issues and to adjudicate those. If you've got non-married borrowers, you're probably going to have to look at doing some sort of partition action in a real estate case to divide that property. Quite frankly, it's just going to be a lot harder to deal with, and the partition action generally does not give you the same range of options. And again, you can also look at filing the bankruptcy and potentially dealing with an adversary proceeding, which is sort of a lawsuit within the bankruptcy to deal with any of these issues that are being raised. All right, for those who are family law attorneys, work with your foreclosure attorneys. Educate the foreclosure attorneys on the nature of domestic violence, its impact on the foreclosure. One thing that foreclosure attorneys are not going to think of unless they've got some background in family law and domestic violence is that the abuser could very well be using this process to collude with the lender or whoever they're trying to sell the property to or whoever's involved, you know, to try to advantage himself and to further abuse his partner. You also have to help the foreclosure attorney understand that she may not have access to information because that's part of the abuse, that he's denying her access to information, and he's set up ways to make sure she can't access it. So you may need to help with the foreclosure attorney understand that it's not someone who's refusing to cooperate, but that she's going to need some help getting this stuff and trying to come up with alternative strategies. You also need to deal with conflict of interest issues. A foreclosure attorney cannot represent, both spouses going through foreclosure. I don't think you can get around that conflict, and I'm not sure that a waiver really covers you. So it may be that the spouses are going to need separate foreclosure attorneys, and how do you deal with that, especially when the spouses have different plans and quite different ideas of what needs to happen next. Foreclosures are equitable proceedings, and so some attorneys have had success with raising the domestic violence as part of the foreclosure proceedings, so that the court can do equity and recognize that as it's dealing with the case. So the ways you can assist the foreclosure attorneys are helping to gather those documents, figuring out how to access this when she doesn't have them, such as online resources and those kind of things, doing discovery in the family law case to maybe get those documents to the attorney to then use in the foreclosure. We're almost out of time, but I cannot end this without talking about the problems of signing the mortgage but not being on the note or not being on anything. So many cases where the survivor has not signed the note, and it becomes a problem. The way this is set up is that generally when a property is transferred, so say, I transfer my house to, XYZ person, that triggers a default in the mortgage loan by that transfer. But there are special laws that say if the transfer is pursuant to the divorce, then that transfer does not trigger a default, the act of transferring the property alone. It's the same protection in the event of death. And so lenders under this same law should recognize an assumption of the mortgage loan pursuant to the divorce without requiring all of the additional underwriting and qualifications that, quite frankly, they always do. This is all kind of found in this federal law called the Garn-St. Germain Act. Some states have a state version of that. There are cases being brought that kind of deal with these issues, and they're trying to protect the rights of both ex-spouses and heirs about dealing with the mortgage company, because the mortgage companies are awful about communicating. They won't allow loan modifications unless you assume, but they won't allow an assumption unless you're current, which you end up in the catch-22, and all of these things potentially violate the Garn-St. Germain Act as well as maybe some state laws. There's a lot of folks nationally looking at doing some of this good impact litigation to try to get at the root of these issues and to change industry practice, but we're not there yet. But if you've got one of these, please feel free to talk to me, and I can let you know where we are and maybe try to get you someone in your area who's interested in looking at these issues. They're tough cases to deal with without serious litigation on the mortgage front, although a decent number of people are finding that once they get into litigation on these issues, that the lenders are at least doing the loan modifications for that individual. There's not a really good answer to those issues except push, 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 and invoke the name of Garn-St. Germain, and don't be scared to keep pushing it and to call in the resources. So I think I am right on time. I'm sorry, I meant to leave 10 minutes for questions, but I can certainly stay on for another 10 minutes or so if there are questions. My email was, I think, on the very first slide. Please feel free to email or call me. I will say that if you email me and you don't hear back in about 2 to 3 days, please email again because it may have gotten lost. I'm not always very good about keeping up on my email. So anyway, any questions, comments, for the good of the group?
Why don't we wait a couple of minutes, just to see if there are any other questions. If folks want to put it into the chat box, we can absolutely stay on for a little while longer.
Yeah.
Okay, I'm not seeing stuff pop up. I really would like to thank Karen Tjapkes for an excellent, really well presented workshop this afternoon. It's really wonderful and chock full of information, and I really appreciate your thinking so carefully about how to do this representation from the perspective of survivors. So thank you for all of this.
You are welcome.
Yeah.
I hope the lack of questions is because it was so informative, not because it was so confusing or boring.
I'm certain that it was a lot of information to digest, and I bet that I would not be surprised if we hear from people afterward asking us some more individual questions. So thanks for your offer to help us with that.
Anytime.
Also, folks are welcome to contact us if you have questions, and we can connect you with Karen, as well as questions that have nothing to do with foreclosure. If there are other consumer advocacy issues that you're struggling with in your representation and advocacy, don't hesitate to contact the Center for Survivor Agency and Justice. You can get us at info@csaj.org. Also, I want to encourage folks to sign up for our listserv if you want to be on top of all of the upcoming resources and trainings that we have in the coming months. And I want to thank everybody for participating today in today's program, and for asking the questions that you've asked, and of course for the work that you all do every single day. So thank you so much. We are also going to have an opportunity to evaluate today's webinar. So we look at those carefully and really do integrate them into our programming in the future. So if you could take a couple minutes to share your thoughts with us, we'd appreciate that too. Thank you all so much, and have a wonderful rest of the day.